Well, I think we are almost ready to start. So if you can please take your seats. Now for the most exciting part of our today's event, which is the questions from the audience, or if you have a position that you would like to share with us, you are more than welcome to do that. So anyone who would like to start this? Yes, please. Just must remind that you should wait for the microphone for the benefit of those who are joining us via video link.
Hello to everyone, and thank you for this very fruitful discussion, and thank you for the organizers, the center of this opportunity to discuss. I was happy enough to be present on some other discussions on the topic which were happening in Vienna. And on one of them, there was Professor Schroer, a very prominent professor whom you, I'm sure, aware of. And I would, as many things which I heard today, I totally agree with, regarding possible problems of the creation of this so-called Multilateral Investment Court. But I would like to transmit to you the question to the audience, which Mr. Schroer has asked. Maybe that would also stimulate some kind of discussion here. So he said that maybe talking about a Multilateral Investment Court, we should also think about long-term repercussions of this decision if this court is created. That is what would happen to the regular commercial arbitration. What if, and this is of course not the perfect citation of what he was saying, but that's a food for thought also. What would happen to normal commercial arbitration, international commercial arbitration? What if this is the first step of some states with regard to more arbitration? The first step is investment arbitration, and then maybe the creation of the International Commercial Court with some kind of same new rules of enforcement and new rules of adjudication and appointment. Thank you.
Sure. I think it's a very interesting question, but I would posit that the state concerns that are being discussed in Vienna and the thrust behind the idea of a multilateral investment court or other form of facility is one that comes from the stance of the states as parties and not of the states as administrators of justice in their respective jurisdictions. Would it spread towards commercial arbitration? I would think possibly any solutions that are identified in the context of the ISDS debate, maybe a solution to some of the problems in arbitrator appointments will spread out onto the world of commercial arbitration. But I think to the extent that parties remain as they are, inevitably at will to choose seats for arbitration, depending on their perception of how any jurisdiction reacts to the needs and to the circumstances of international arbitration. The states who want to regulate more will simply be chosen less as a seat of arbitration, and that's going to create arbitrage in arbitration, if I may be allowed the pun. But I don't see much of a risk of this springing out negatively onto commercial arbitration. I would invite any different views just for the fun of a good fight anyway.
No, I wish I could disagree. I don't think I do for the same reasons Diego mentions. I think one thing, though, is clear is that let's call it poison, that is currently in the debate for ISDS is spilling into commercial arbitration, in the sense that it's just arbitration that seems to take the ire. And if it's true that there's a bleed from ISDS to commercial arbitration, then I don't think Schroer's position that there could be some repercussions from ISDS court to commercial arbitration are that far-fetched. In other words, I could see, because there is such a linkage between the two, at least now in the perception of the minds in the States. It reminded me, though, of there is even criticism now in the United Kingdom, for example, of commercial arbitration by the government or certain judges. Now, I think that could be unique, because what they say is, well, what we have in England is the common law, where people go to court for their commercial disputes and the law evolves. But what's happening, according to some of the judges and the Ministry of Justice, is those cases are going to commercial arbitration, which is not allowing the law to evolve. So I can see maybe something of that argument if states are interested in the evolution of commercial law in their countries and too much work going to commercial arbitration. But I see predominantly judges and ministries happy that commercial arbitration is taking the burden off the courts. So perhaps, that dichotomy won't exist.
Now, if I may just add to that, I think the one way where I think this discussion is a bit of a poison is a commercial arbitration involving states and state-owned entities, because there is a debate that it either must be very, very transparent or it must be allowed with certain restrictions. Certainly, it's something that in Russia is already, or at least reflected in the position of the Russian courts. But also, I heard colleagues from Germany saying that Germany has recently been involved in a number of very costly commercial arbitrations, and there has been on the heels of this investor state dispute settlement discussion, also very huge criticism against the government for using commercial arbitration, and also for resolving. I think the core dispute there concerns operation of a toll road, and so they said that the operation of a toll road and tolls and everything, again, should not be hidden and should not be delegated to these secret courts, as they say.
Thank you. My name is Professor Anton Asoskov. I'm from the Lomonosov Moscow State University. Thanks a lot for all speakers for their brilliant presentations. And the question which I want to raise is about the way how this potential new system might interact with the existing one. So if, for example, let's imagine that this idea with the multilateral investment courts will be materialized. But if we just say that we need to wait when this option would be included into the existing BITs, then maybe for dozens of years there would be no practical application. And I see today I've just looked at the website of UNCITRAL, and there is an interesting new recent note by the Secretariat which also touches this issue. And as far as I understand, the proposal of the UNCITRAL Secretariat is to say that if particular states ratify the proposed instrument, and they say these particular states that they want to choose certain options, then they will be applicable also to existing BITs without the necessity to amend them. And in connection with this, I have a question. What do you think? Do you see here any problems from the perspective of so-called legitimate expectations of investors, that at the moment that when they made investments, certain options were available, for example, ad hoc arbitration, under UNCITRAL rules. And then later on, just because two states agree to implement new options and, for example, to abandon the existing one, then the investor has to use totally different mechanism, for example, of this multilateral investment court. So do you see a problem here, or you think that this proposal is perfectly correct? Thank you.
I'll just make two points. I think it's a brilliant question. Just to address the first part, so something similar has been done with the Mauritius Convention on Transparency. So it's simply you sign the agreement, which then magically amends your bilateral investment treaties if the other party has also signed the Mauritius Convention. So it's a sort of throughout all BIT. So it avoids the need to amend each BIT. I think I see no reason, at least in my mind, and thinking of it in a sort of contractual framework, why if the two parties agree in a subsequent agreement to amend a prior agreement as between them interstate, that is sufficient to amend their agreement. The more interesting question, I think, is your second one, which is, well, what about the investors who invest on year one, where the treaty has, for example, ad hoc UNCITRAL arbitration, and I'm so happy that it has that as the investor, and I invest, you know, part of the reason I'm investing is because that's there, and in year four, now all of a sudden I'm faced with a multilateral investment court. And I think my answer to that would be, it depends on how you view the investor rights under the treaties. Are they standalone rights of an investor, like human rights? So they are embodied into the investor, separate from what I would call more derivative or conditional rights, which are simply hanging off their government. And if their government decides to change the game, then the investor has absolutely no recourse, no choice but to accept the fact that their rights are conditional on the whim and will and agreement of their home government. And if the home government changes that, then the BIT simply changes for them. The slight nuance I would put to that is, what if the dispute, what if the delict, the international dispute, happens first, then there is a change? Does that change? What if I've triggered, another twist could be, what if I've triggered the arbitration provision and then there's a change? So I can see various data points along the chronological spectrum where these kind of questions of derivative rights and whether they're standalone rights or conditional rights could take place. But at least my worldview would be the rights are completely conditional. And if your home state changes it, just as if, for example, I want a visa and I book my ticket to go on holiday and I'm about to get the visa and that the night before the two governments decide we hate each other and there's no visa, I'm out of luck, right? I could say I booked my ticket on the expectation I'd have a visa, the visa's gone because my government and my rights are, my government decides my rights.
I agree with the very, very interesting questions. I think this, for the first question, the starting point is very relevant for a portion of the caseload, but not for the entirety of the caseload. There is a number of investment disputes that are based on contract and not treaty. And so for those, subject to how we interpret and how the data points, as Beja called them, play out in the particular context of a dispute, there's perfectly well a universe where the contracts that have a recourse to investment arbitration will be probably the earliest adopters of this new multilateral instrument investment, whatever impact that has procedurally. This is not entirely unlike what happens with arbitration institutions changing their rules. And just to give you an example, the ICC amended the rules in 2017 to basically establish a semi-mandatory expedited procedure for cases south of $2 million. No matter what your contract said, if your claim starts after the rules came into effect, that's what your contract now says. Even if it said that it would have 3 arbitrators, and the ICC now says, well, smaller cases now have 1 arbitrator, except in very exceptional circumstances. I mean, all I mean by this is there is a growing caseload of situations very similar to these that have already been decided. Now, to the second question, Beju's proposition is very interesting. I think just to add, if not to have a beef with that theory. As he said in the case of what if my state then terminates the visa arrangements with the state I was supposed to travel to, you wouldn't have a claim which is valid under international law against your own state. By the same token, if the 2 contracting states have amended their BAT, the amendment is not attributable to the host state, but instinctively one have to say it goes to a measure adopted by your own state, which is not sufficiently a valid cause of action in international law. So I think that is also another interesting element to put into effect. Having said that, I'm pretty sure that the discussions this next week in Vienna will certainly include a very thoughtful consideration of the data points that Beju identified, which I think are very relevant for the vast majority of the situations where this may arise.
If I may add, on the second point about the legitimate expectations question, another dimension, at least to my mind, would be how one conceives of the right related to the dispute settlement mechanism of the investor. Is it I would tend to think that it is a right to firstly, to be able to submit a claim if your rights are violated, and secondly, to do so outside of the courts of the host state in order to be able to potentially depoliticize the conflict. But I wouldn't be sure, or at least there would be a question as to whether it attaches to the very specific mechanism by which this protection and this possibility to submit a claim is achieved. And on the practical side, imagining the situation that you described, I imagine this question coming to the multilateral court that now exists, and the argument being made that the legitimate expectations were frustrated because the court is not as good, because in some way the protection is lower than if the investor had access to an ad hoc arbitration system. And I have difficulty imagining this court saying, oh yes, we cannot give you the kind of independent decision making that you would expect in the other system, just in practice.
Sorry, just one very quick point. Another way, as I'm thinking about it, is that we say that the state makes a standing offer of arbitration and that the investor accepts that offer on the submission of a claim. But I think it's fair to say an offer can be revoked prior to acceptance of the offer, at least under standard contractual understanding of procedure. And therefore, if I've made an offer to arbitrate ad hoc, I can revoke that offer prior to your acceptance. The only question will be if that offer is interpreted as vested because you invested on the basis of the offer, and therefore it's crystallized for you, and I'm not able to revoke it. Personally, I stick with my original theory, which is that it can be revoked, but it's just another way of thinking about it is offer and acceptance under contract.
Clearly an unusual question, because I also had a thought as you were speaking about how that would interact with the provisions for the termination of the treaty. Because of course, there is a situation where the offer can be entirely revoked with the termination of the treaty, and there are usually sunset provisions and so on. So I was wondering how that would actually interact with the revocation of only part of the offer.
I think what makes Evgenia's point very interesting is that by amending the dispute resolution clause in the treaties, the states would be amending probably the sunset clauses in that same treaty. So it becomes a booting problem, trying to lift yourself from the ground, just pulling from your own bootstraps, and that is something of a problem that will not be very easily or very satisfactorily solved for all parties involved. And to Badger's point, the issue is not entirely unheard of, and you have to perhaps take guidance from the still unsettled issue of how you denounce the ICSID Convention, for instance. And as I mentioned, there's cases out there where tribunals under the ICSID Convention have said a new claim cannot move forward, whereas you also have decisions saying a new claim can actually proceed. And ICSID has continued registering cases against Venezuela. I'm working on a case representing Venezuela where the claim was brought in 2018, 6 years after the ICSID Convention had been denounced by Venezuela. So that hasn't still gotten a decision, but ICSID did register the case. So there's still enough fuel for an interesting bonfire there.
Thank you. Yes, over there.
Yeah, thank you very much. My name is Alexander Plachov, and I'm the head of the Russian delegation to UNCITRAL. On behalf of the Ministry of Economic Development of Russia, we would like to thank the Center for organizing this event, and to speakers for sharing your views. And as you may know, we have submitted 2 documents to UNCITRAL, 188 and 188 Addendum 1. We tried to answer a lot of questions on EU initiative. I mean, how many cases will be in new court? How many judges do we need? How much money do we need for this court? But it's like a second step question, probably. The main issue is the creation of the court itself, because we, as you know, the Russian Federation doesn't support the creation of this court, because we think that the creation will not resolve all problems, and moreover, it creates the parallel system to current arbitration institution as ICC, Stockholm Chamber, LCIA, because some of the states will not join this convention for sure, and they will continue to bring cases to these arbitration institutions. And it means that the main aim of the reform, the coherence and the consistency of the practice will, I mean, is not reachable. But the question probably to the speakers, do you think that the appellate body or ad hoc appellate mechanism is necessary to the current system? Because it's obviously that we need to change and we need to resolve some problems in investment arbitration. For example, double heading and the same judges, the same places, the same institutions. But is the appellate mechanism necessary for the current system and will help us to resolve any problems in investment arbitration or not? Thank you.
Those are all very, very interesting points, and I'm sure that they will be weaved into most of the debate that will happen next week in Vienna, because they are, no matter what, to the extent that any proposition towards the establishment of an additional device, be it in Multilateral Investment Court or an appeals mechanism or not, if there is any decision adopted to actually go ahead with that, those issues will be front and center of any debate, because it's very hard as of now to put a tag on what size it should have to actually cope with the number of disputes. And this is something that if you go through the list of people working at ICSID, you will notice an unreasonably high number of Spanish speakers. The reason is because until the Argentine cases started being filed in 2002, 2003, ICSID didn't have personnel of its own. It just used personnel from the World Bank on secondments. And when they needed to cope with 45 simultaneous new cases, they had to go and get people who could actually understand the language that was being discussed in the regulator. So it had an impact on the shape of the center, and one would hope we will never have a spike of cases for any new multilateral investment court as ICSID had in 2002, 2003, but careful planning of that has to occur. A more profound issue, which is an appeals device necessary. The ICSID system is premised on the notion that the remedies that are allowed under Article 54 of the Convention, meaning that, of course, Convention says no remedies except for those in the Convention can be had against an award. And the interpretation that is given is that the system allows for correction of minor mistakes through revision, correction, interpretation. There's no remedy for big mistakes. So a system that allows for correcting small errors but sleeps well at night knowing that there's no remedy for big errors, to me, is an invitation for disaster. And disaster has occurred. We have decisions which are absolutely contradictory, applying the same measure by the same or related parties, by the same respondent state, discussing the same measure under the same treaty, which are absolutely opposite. One of them has to be wrong, and finding a solution, maybe it's appeals, maybe it's cassation. One of the positions that was discussed at the sessions in Working Group 3 was that maybe it's not a one-size-fits-all solution that we should aim for, but a menu of remedial options that where possible goes to cassation, where if we're actually talking about decisions dealing with the same exact issue, that would deal with, for instance, interpretation problems under the ICSID Convention, and all of the issues about what Article 25 of the ICSID Convention mean, whether an investment has to be identified or defined, they could all be cassated through some device. Issues of interpretation of Article 3 of one particular treaty are not easily subject to cassation with any other 3,000 plus treaties out there. So maybe another device such as appeals or some additional mechanisms for providing a remedy towards a defective award should be implemented. Some form of remedy, having represented Argentina, Venezuela, and Bolivia and Ecuador in investment cases, meaning countries that have faced a very large number of cases by tribunals that sometimes shared a member and reached different results. It is my view, and this is of course a personal position, is unavoidable and is the only way that a system can survive that creates incentives towards going to arbitration and not diplomacy.
Thank you for. First of all, let me congratulate you on the papers. I read them in preparation for this, and I think they strike the right tone and they engage, but at the same time push back on the MIC, which I think is right. I think your position on the appellate mechanism is you're willing to hear and discuss more, right? You're open-minded. I think is the position you take. So then your question comes to, well, do we need it? And I have to say yes. And the reason I say that is as follows. In commercial arbitration, parties usually want finality. So they don't want appeal because they want to get on with business. And that's a great attribute of commercial arbitration. Here, we're talking about huge cases, sometimes multiples of percentages of GDP, over incredibly important issues: health, energy, tax, environment, and no way of dealing with a bad decision. And I think that's a very dangerous recipe for a country to take a regulation that is bold but important for its people, be sued by an investor, or as in Argentina's case, a series of investors, or sorry, I say bold, but bold regulation, but also a case of necessity. You have a situation where you're faced as a state with doing whatever you can to, pay your nurses and doctors, and so you're faced with a situation where you've then got investors who will sue you in a series of cases for literally billions of dollars. You're putting your entire faith on 3 individuals or a series of tribunals. There are going to be some bad decisions in there. Now, that's a system that's what I would call all in, right? You're all in. Either it'll come out good or it'll come out bad, and I find that difficult from what I would call then a public administrative position, where governmental acts of that nature, of that seriousness, that the money comes out of taxpayer money, has to have some methodology to deal with bad decisions. Because if that bad decision is huge, then the ramifications are enormous for a country, particularly countries that are developing that can't pay. So I would say, yes, we need something, so I agree with you, it's something, but it's the question of what it is, I haven't yet formulated in my mind. What I think is important, though, most important, is who is on that appellate mechanism. Again, it goes back to the question of diversity. Again, in preparation of this, I was reading about the ICJ, and I remember the furore there was in London a couple of years ago when the UK, for the first time in its history, didn't have a judge on the ICJ when Chris Greenwood sort of got voted out. And it was so used to having its place at the table because of its membership of the Security Council that it was unbelievable to them that the ICJ couldn't have a UK judge. And my worry about the MIC and an appellate mechanism is that the same countries with the same people are simply going to take their spots either by voting and pressuring and bargaining, and we're going to end up in a situation countries, again, are now beholden to a court which is based around the same thing, and you've lost your ability to pick your own arbitrators, which at least is something where you have a voice in the system. So I think, again, you're right to say appellate mechanism, let's discuss it more. We're open, because I think bad decisions have to be dealt with, but I think very careful about what that then looks like.
Let me start by the last point, which I totally agree with. A court, international or domestic, is not only the building, the rules, the institutional framework, is primarily the judges. So if you ask me, are you in favor or against the investment court system, without knowing the judges and without even knowing how the judges are going to be selected, it's very hard to form an opinion. It's like asking me, are you in favor of the US Supreme Court? Which US Supreme Court? The US Supreme Court of the 19th century or the US Supreme Court of the 50s, the 60s, and the 70s? Two very different courts. More generally, I think the is it necessary question is of fundamental importance, obviously, and I think part of the problem is the following. The stakeholders, or the majority of the stakeholders, agree that something is wrong with the system, but they don't agree on what is wrong with the system. For example, for some, what is wrong with the system is that there is too much protection of private property rights. For other people, the problem is that we have international scrutiny. So some people, they don't want states to be able to be held accountable before international courts and tribunals. And we see that with international commercial arbitration, and we see that, I think, extremely well in the current legitimacy crisis of the World Trade Organization. Some other people, they are concerned with specific issues of transparency, double hatting, selection of arbitrators. So unless we agree on what is wrong with the system, which I don't think we all agree, we cannot find the appropriate solution. And a last point, a clarification question to Diego, if I may. I understand, and please correct me if I'm wrong, that part of the problem regarding the lack of consistency with the Venezuelan case that you mentioned is that Venezuela denounced the Exit Convention without amending the sunset clauses in the BITs as you suggest earlier. Because had the Venezuela amended the 10, 15, 20-year sunset clauses in the BITs and denouncing the exit convention, obviously there would be no problem. Thank you.
Just very briefly so I've represented Venezuela in 2,000 cases, including a full dozen of cases that were initiated after the denunciation. The issue of when the issue of the impact of the language of the BIT on the denunciation of the treaty was raised and very rapidly discarded in one of the 12. And I think that statistics go even to the cases I was not involved in regarding the denunciation of Venezuela. The is dealt with in self-standing terms by Article 71 and 72 of the exit convention, and all of the discussions where there's been opposing views by tribunals, I only bring them up to the extent that they are opposing views on the language and interpretation of Article 71 and 72. There may be or may not be a treaty, maybe it was a contract case, and I wouldn't care for purposes of what do we make of Article 71 and 72, which I think is the issue that remains unsolved.
If I may just add a couple of things to that. One, I think there are two different concerns going to appeal. One is the